Last week, the United States Supreme Court, in a 6-3 decision, invalidated the New York State Eviction Moratorium. Now, before you start celebrating too much, you need to understand the nuances of this decision, as well as what's about to happen on the state legislative level and on the federal level more broadly. While this is a victory of sorts for my fellow landlords, I think it may prove to be a very short one. I'll explain what I mean coming up. Hey guys, if we're just meeting, my name is Vitaly Volpov. I'm a practicing attorney, an active real estate investor, and a part owner of a real estate brokerage in upstate New York. I have been successfully investing in cash flow and rental properties since 2011, and I currently have 68 rental units in my real estate portfolio. On this channel, I discuss relevant legal concepts as well as best strategies and tips for real estate investing and personal finance. If you're new to the channel, consider subscribing and hitting the notification bell so that YouTube notifies you of all my future content. If you enjoyed the content in this video, hit the like button and comment down below. Now, before we talk about exactly what happened at the Supreme Court and the court below, I think it's important to go through the history of the eviction moratoriums and where things stand right now in New York State. March 20th, 2020. Governor Cuomo issues the first executive order number 202.8. This order imposed the first 90-day moratorium on residential evictions in New York. May 7th, 2020, Cuomo issues another executive order number 202.38, which allowed tenants to use security deposits towards rents due while quote-unquote temporarily prohibiting landlords from initiating eviction proceedings against tenants who are facing financial hardship due to the pandemic. This executive order extended the eviction moratorium through August 2020. June 30th, 2020, the New York State Legislature passes the Tenant Safe Harbor Act, and Cuomo promptly signs it into law. This act prohibits courts from issuing eviction warrants or possessory judgments through quote-unquote the end of the COVID-19 covered period. This phrase was defined by reference back to the series of Cuomo's earlier executive orders, which defined the period as starting on March 7th, 2020, and running until such time as businesses were permitted to reopen and restrictions on gatherings ceased. Notably, the vagueness of this definition means that the Tenant Safe Harbor Act remains in effect since not all restrictions have been lifted. At least, this is how the federal courts, in this case we're about to discuss, have interpreted this act. Fast forward to December 28, 2020. The New York State Legislature passes, and Cuomo signs into law, the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020, abbreviated as SEFPA. Part A of this act imposes a new eviction moratorium. The scheme created by this act incorporated a quote-unquote hardship declaration requirement whereby a tenant who attests to being negatively impacted by the pandemic is thereby completely protected from eviction until May 31st, 2021. The hardship declaration, once signed by the tenant, could not be challenged in court and conclusively precluded landlords from proceeding with any eviction in court until May 31st, 2021. Additionally, the hardship declaration, which required no proof whatsoever from the tenant of an actual hardship, created something called a rebuttable presumption, which would survive the expiration of the act past May 31st, 2021, and could be used as a defense by tenants in a subsequent eviction proceeding. Fast forward to April 23rd, 2021, the New York State Legislature passes, and Cuomo once again signs into law an extension of SEFPA through August 31st, 2021. And this is where our current case begins. In May of 2021, 5 individual landlords and a landlord association filed a complaint in the federal court in the Eastern District of New York, arguing that SEFPA should be invalidated on various constitutional grounds. In June of 2021, the district court dismissed the case, denying all relief requested by these landlords. The plaintiffs subsequently appealed this decision to the Second Circuit Court of Appeals, and that appeal is currently pending. While this appeal was pending, the plaintiffs also petitioned the United States Supreme Court for temporary injunctive relief, preventing this law from continuing to be imposed. One of the arguments made by plaintiffs at Supreme Court was that SEFPA violated their constitutional due process rights by conclusively and automatically accepting a tenant's declaration of hardship and preventing the landlords from challenging this declaration as to its truthfulness. Shockingly, the United States Supreme Court sided with the plaintiffs on this issue and determined that SEFPA, to the extent that it addressed eviction moratoriums, was unconstitutional and therefore invalid. Specifically, the Supreme Court said the following: if a tenant self-certifies financial hardship, Part A of SEFPA generally precludes a landlord from contesting that certification and denies the landlord a hearing. This scheme violates the court's long-standing teaching that ordinarily no man can be a judge in his own case, consistent with the Due Process Clause. Having agreed with the plaintiffs on this issue, the court went on to grant them the temporary injunctive relief which they were seeking, meaning that Part A of SEFPA, the part that relates to the New York State Eviction Moratorium, will be of no force and effect until the Second Circuit Court of Appeals renders its decision on the plaintiff's appeal. And if that case is also further appealed to the United States Supreme Court until that court renders its decision. Because the appeal to the Second Circuit and possibly to the United States Supreme Court is likely not going to be resolved before August 31st, 2021, the present decision from the Supreme Court granting this injunction essentially kills SEFPA's provisions relating to the current eviction ban. However, this is far from the end of the story. As soon as the United States Supreme Court decision was handed down last Thursday, politicians in New York immediately took to the media and social media to talk about what they're going to do in order to get around this new ruling. Specifically, State Senator Brian Kavanaugh, one of the architects of SEFPA, made the following statement to the media. He said, "I'm going to be looking at SEFPA in light of the court's opinion and figuring out if there's a way to shore up the law." The court did not say we can't have a moratorium if someone is experiencing hardship. They're saying it can't be based on self-attestation, so we're going to be looking at if that can be amended. At the same time as Mr. Kavanaugh was making this statement, our new incoming governor, the current Lieutenant Governor Kathy Hochul, was tweeting and saying that she looked forward to working with the legislature to quickly address the Supreme Court's decision and strengthen the eviction moratorium legislation. So what does all this mean for landlords in New York? Well, first of all, this last United States Supreme Court decision has no impact on the federal moratorium. As you may have heard, the CDC issued a new eviction moratorium which now covers approximately 90% of the country. That moratorium is being challenged in court and will likely be struck down. However, it likely won't happen before its own expiration on October 3rd. So while the legal challenge to that moratorium winds its way through the courts, that moratorium will remain in effect and will likely apply to many parts of New York. Additionally, the U.S. Supreme Court decision which we're discussing expressly left the New York State Tenant Safe Harbor Act in place. While that act does not prevent landlords from bringing tenants into court, it does allow tenants to use pandemic hardship as a complete defense to evictions. It then becomes a he said, she said situation in court, and the eviction judge will get to make a decision as to whether he or she believes the tenant or believes the landlord, and whether or not the eviction should be granted or denied. Finally, as I just mentioned, the New York State Legislature and the new governor are likely to either pass a new law or amend SEFPA in the next couple of weeks to prevent any evictions from actually occurring. So while this is a victory for landlords, it's likely to be an empty one. And I'm sorry to be the bearer of bad news and the pessimist in this case, but I really think that very little is going to change in New York with regard to evictions as a result of this decision. So if you're a landlord, what should you be doing right now? Well, I really see only two options. Option one is you initiate an eviction or continue with an existing eviction and hope that you can get a tenant out before the state takes new action and creates a new law which will prevent you from doing so. But given the federal eviction moratorium which is currently in place and the Tenant Safe Harbor Act defense that tenants can utilize, I think your chances of winning in court are pretty slim. Option number two is to apply for the New York State rental assistance. If you didn't know, New York State currently has $2.3 billion allocated toward providing rental assistance, which goes directly to landlords. The problem is that your tenant does have to cooperate in the process, provide various documents, and answer a lot of very personal questions. So if your relationship with the tenant and your lines of communication with them are irreparably broken, then this may not be a very viable option for you. If you do want to apply for rental assistance and want to know how to do it, check out my tutorial on this topic that I'll put a link to in the description below and in the YouTube card above. There really aren't too many other choices right now besides trying to proceed with an eviction or applying for rental assistance. And unfortunately, I foresee eviction bans being extended either on the federal level or the state level or both through the end of this year and possibly well into next year. As you know, Democrats currently control the New York State Legislature, the New York State Executive Branch, the United States Congress, and the presidency. And since their motto is never let a good crisis go to waste, you can be sure that they will milk this for as long as possible to try to get as many people on the government dependency train as they can. So with that said, guys, that's going to do it for this video. Thanks again for watching. I really appreciate it. If you enjoyed it, please do me a favor and hit the like button. And if you haven't yet subscribed to my channel, definitely subscribe so that you don't miss any of my future videos. Thanks again for watching. Have a great day, and I will see you in the next one. Take care.